Hi, thanks for using my court coach. I'm Sarah, and I'll be your instructor today as we talk about the request and declaration for final judgment of dissolution of marriage. This is also known as Form FL-970. As with all our court forms, you want to fill in your identifying case caption information at the top. You would use this form if you've already submitted a judgment, but have reserved on the termination of marital status. If you've now changed your mind and would like that marital status to be terminated, this is the form to submit along with your FL-180, your judgment form that would be for status only. So to fill out this form, you want to list the date that the court acquired jurisdiction of the respondent on, and that's going to be either the date the respondent was served or the date that the respondent filed a response to this action, whichever occurs first. You would want to list the date of the judgment, what day that was entered. It states here, or refers to it as an interlocutory judgment of dissolution. All that means is that it's a judgment of dissolution of marriage where the marital status hasn't been terminated. So go ahead and write in the date that was entered. Below that are just some representations being made that since the entry of that judgment, the parties have not reconciled, they have not agreed to dismiss this proceeding, there is no pending motion to set aside or annul, and there's no appeal currently pending from that judgment. So provided that's all true, you can go ahead and continue to fill out the rest of this form. Then in line 4, it states that you're requesting that the final judgment of dissolution be entered. There are some other options that you can fill out below. You don't have to. If it says cut and dry as you submitted a judgment that reserved jurisdiction over termination of marital status, then you can be done with this form after signing and dating below. However, there are some options that may apply to you. If you have filed a joint petition for summary dissolution and have now decided that you don't want this case to proceed as a summary dissolution, and at least 6 months has passed from the time you filed that joint petition for summary dissolution, then you can still ask for entry of final judgment. And again, that's just going to be a judgment that gives you the date that the marital status is terminated. If it was filed as a joint petition for summary dissolution, you still need to resolve how the assets and debts of the marriage are going to be divided, and that would be in a separate judgment. But if all you're looking for is just the date of termination of marital status, then you can go ahead and mark this box. You will also need to provide conformed copies. That means file stamp copies of the joint petition for summary dissolution that was filed, as well as a notice of revocation. That is a form FL-800, and it basically says you are withdrawing your request to have this case proceed as a summary dissolution. If you are asking for the judgment to be entered nunc pro tunc, that's our Latin term for going back in time, you would mark box 4B and list the date that you want the judgment to be entered as of. In other words, what date do you want the marital status to be terminated as of? Nunc pro tunc is going to be up to the courts. They can only grant them in certain instances where there has been some sort of mistake or negligence that led to the judgment not having been entered sooner. So if you believe that you fall under that category, provide your explanation below. And as I said, it will be up to the judge who is reviewing this judgment. And then finally, if there's any other requests you have pertaining to the request and declaration for final judgment of dissolution of marriage, you can go ahead and specify what those are in line 5 below, fill in your name at the bottom, sign and date, and now this form is ready to be filed along with your FL-180 judgment form that's asking for the termination of marital status. I hope you found this helpful. Good luck.